Okay, moving on to the particulars of sale, you would have obviously the selling price. How much is this property being sold for, right? So make sure if you're the buyer that it's the same amount that you have agreed with the seller. Then you'll have there the amount of deposit required. Is it the same as the amount of deposit stated in the contract of sale, the same as the agreed upon deposit? Now in Victoria it could be 5%, it could be 10%, or even more. It really depends on what's agreed upon by both parties. Now, with regards to the deposit, there's also the due date beside it. When is the deposit due, right? So you have to take note of that. And then the balance due at settlement. So uh, how much is required for you to be able to purchase that property after paying the deposit. And then the most important part, obviously, is the settlement date. This is the date when everything will be exchanged. Money will be exchanged, and your and the seller will be able to receive the funds, and the buyer will then have their names registered on that particular property that they're buying. So that's the settlement date. Now, what are the other things that could be found in the contract of sale? There are conditions prior to settlement. So these are things that should happen before settlement occurs. And what are these? One is the finance clause. This is most often than not a very important clause, because this states that this contract is valid if, or is subject to the buyer being able to obtain an unconditional approval from their lender for a particular amount. So the finance clause would have these things. One, which lender is the buyer trying to apply for finance? Two, how much amount is the buyer requesting to borrow? And three would be the date, or the final date, where the unconditional approval should be received by the buyer. And after this date, so this before this date, the buyer can still cancel this contract if they're not able to get an approval from their lender and be able to still get back their deposit. After this approval date, then the contract becomes unconditional, meaning whether the buyer gets approval or not, this contract is binding or unconditional already, and cannot be you cannot renege on this contract anymore as the buyer. Next, building inspection clause, or building inspection report, and pest control report. They usually go together. So for buyers who are wanting to purchase a property with improvements or with a house on it already, then your contract of sale gives you a condition stating that, look, this contract will be binding if you're able to get an inspection report and a pest control report prior to a specific period, right? So there's also a due date on this. So this gives the buyer a chance to get a building inspector and a pest control inspector and have a look at the property and see if that particular property is acceptable to them or not. and the building and pest control inspector will be able to provide a report wherein the buyer can then say, look, all right, I'm happy with the property that I'm buying, so we're good to go on the contract. If the buyer is able to get a report that is not favorable before the due date of the building and the pest control reports, then they would have uh, an opportunity to cancel the contract based on the reports that were the unfavorable reports that they received from the inspectors. Next, lease. As Rochelle will be discussing later, there's a there are times wherein there's a buyer who's going to buy a property with a tenant in it. So the lease clause would tell you that there is a tenant and what are the terms of the tenant, and what are the terms in the lease agreement, as a sign of disclosure. Last but not the least would be special conditions. Okay, so now in special conditions, these usually are terms and conditions that the seller would like to put in that were not mentioned in the particulars of sale. So it's a free for all part of the contract of sale, and each solicitor, each legal practitioner would have their own way of putting terms and conditions in there. And I highly advise the buyers to ask their legal practitioners to explain what are these special conditions, right? Anything that might be particularly relevant to the buyer. For sellers, special conditions usually, since they are put in by the seller's legal practitioner, most often than not favor the sellers, right? So it's good to know what these special conditions are, because at least you know what are your rights and duties in terms of the transaction, the contract that you're getting into. Do note that special conditions are not only for sellers. Buyers are also able to put in special conditions of their own. I've seen some special conditions that are put into the contract from the buyer side. Say, for example, like I'd like I'd like the landscape to be finished before settlement, or I'd like the furnitures to be cleared out before settlement. And those special conditions can be put in the special conditions part of the contract to be agreed upon by both parties. So it's not just the seller's space, but also the buyers could also put in conditions there in special conditions. Just like to remind everyone that if you've got questions, please don't hesitate to put them through in the chat. All right, cool. So that's the first part of the contract of sale. The second part of the contract of sale is what we call the vendor statement, or Section 32. Section 32, because it's called Section 32 because it's in accordance with the Section 32 of the Sale of Land Act 1962. Vendor statement, as the word as the words imply, basically it's the seller's disclosure of what they're selling. Right? So this document basically presents or provides the buyer information relevant to the property that they are wanting to purchase or wanting to buy. right? So the first page of the vendor statement would have a signing page of the vendor and or the seller and the buyer, meaning once they sign on the signing page of the vendor statement, the seller saying that I confirm everything that is in this document to be true. And once the buyer signs the vendor statement, the buyer is committing that I have already read and understood this document, and I know and I have sufficient information uh, about the property that I'm buying. Okay, so that's the vendor statement or Section 32. So when you're a buyer, most often than not, the agent would say, "Would you like to have a copy of the Section 32," which is the seller's disclosure of what they are selling. So what does the Section 32 contain, right? So first and foremost, it has to have the what we call the Consumer Affairs Victoria's due diligence checklist. Again, just to repeat what I've said earlier, we would be talking about a property transaction specific to Victoria. That's why it's Consumer Affairs Victoria. Now the document is a checklist prepared by Consumer Affairs, right? And the checklist basically is a checklist of what a buyer needs to know before buying a residential property. So it would contain points like is the property subject to an owner's corporation? What does that mean? Is there a flood and fire risk on that property? So these are just small tips, of information that gives you a hint of what to look for in the vendor's statement, you know, in your Section 32. So it gives you a little bit of an understanding of what you're looking at in your Section 32. So in your Section 32, I would really advise that as a buyer, you have a look at what is contained in this Section 32. You might find it daunting, but just bear with it because you would need to know, or you would like to know what you're buying, right? So you need to have information of what you're buying. And what does the Section 32 contain? So the Section 32 contains one, financial matters. What does that mean? Financial matters meaning what are the rates, duties, and taxes that are outstanding as to the property that you're buying. Are there any rates and taxes due? You have the insurance. If there's any insurance applicable, like owner builder's insurance, damage and destruction insurance. Land use, meaning what does the council plan on that particular, is there any plans on that particular property that would affect that particular property? Road access, is it a designated bushfire prone area? You would see those in the Section 32. Are there any outstanding notices or orders that affect this particular property? Is it under compulsory acquisition, say for example, meaning are there any notices of intention to acquire this property, as they have they have stayed for there in that property for more than 15 years? Then you've got building permits. Now in Victoria, there's the rule that any improvements in that property within the last 7 years should be declared, and therefore you have to have building permits and attached to this particular Section 32 if there are any improvements that require building permits that were made within the last 7 years.